Welcome to our education video on breaches of the agreement. My name is Mark Fiddler and I will provide information for all parties involved in a tenancy on how to navigate the breach of agreement process. We will look at the breach process, including what a breach is, the notices that need to be issued, whether that's a Form 11 or an R11, timeframes required to be provided to remedy a breach, and steps taken if a breach is not remedied. Before we look at the breach process, I do want to touch on communication in a tenancy. Communication is key to resolving most tenancy problems. Being respectful in any communication and getting in early to talk can help resolve a matter before it escalates. Look for options and solutions early. It's important to understand rights and responsibilities for both sides, share information, listen, look at options and workable solutions, and if you agree to something, document it. Now let's talk about breaches. So at the start of a tenancy, parties sign an agreement that contains the terms that the parties should abide by throughout the tenancy. The standard terms and any special terms will be set out in the agreement, and any body corporate bylaws for a tenant living in a flat, unit or a townhouse that is covered by body corporate bylaws, park rules for tenants living in movable dwelling parks or house rules for residents living in rooming accommodation also form part of the tenancy agreement. If there has been a dispute and a conciliation agreement has been signed off by both parties, then this forms part of the agreement and the parties have a responsibility to abide by the terms of it, and similarly with any tribunal order that may be made during a tenancy. If either party does not comply with any of these things I've just mentioned, then they may be considered in breach of the agreement. The Residential Tenancies and Rooming Accommodation Act of 2008 states that if a tenant is in rent arrears or has breached another term of the agreement, or the tenant believes on reasonable grounds that the lessor has breached a term of the agreement, then a breach notice can be issued. Now, the RTA encourages the parties to discuss any issues that may come up through the tenancy and work together to resolve them before going down the path of issuing a breach notice. For example, if a property manager or owner notices that a rent payment is overdue after months of rent being paid on time, is immediately issuing a breach notice the best option? Or if a tenant has requested repairs and there is a delay, is a phone call back to the agent to check what's happening a better option than going straight to a breach notice? If there are concerns about the issuing of a breach notice, either party can apply for dispute resolution through the RTA. And if the matter can't be resolved, the parties can apply to QCAT for an order about the matter. Issues that we commonly see resulting in breach notices being issued are listed on the slide. As I mentioned earlier, we would encourage parties to discuss and attempt to self-resolve any issues before issuing a breach notice. But if the notice does need to be issued, then there are minimum timeframes that need to be adhered to depending on the type of tenancy and the reason the breach notice is being issued. For a general tenancy, if the rent has remained unpaid for 7 days or there is a general breach, the minimum time frame to rectify is 7 days. This is the same for a general breach for a movable dwelling agreement, but a rent breach for a movable dwelling agreement, the minimum is 5 days. If a tenant is issuing a breach to the property manager or owner for either a general tenancy or a movable dwelling, they must provide a minimum of 7 days for the other party to rectify. Rooming accommodation agreements that are less than 28 days old need to provide a minimum of 2 days to rectify a rent breach, or 4 days if the agreement has passed the 28-day mark. General breaches, regardless of the length of the tenancy, are a minimum of 5 days to rectify, and this time frame also applies for residents issuing a general breach to the provider. It is important to note that these timeframes are minimums and parties can choose to provide longer if they feel the need to do so. So now that we're aware of the required timeframes that must be provided, let's look at the notice to remedy breach itself. For general and movable dwelling agreements, the notice is a Form 11. For rooming, the notice is an R11. It's important to fill out the notice correctly and in full, and please ensure that details of the breach are clearly stated on the form. If you are issuing a breach notice for rent arrears, you can only request the amount outstanding at the time the breach notice is issued. Any amounts that become due during the period the tenant or resident has been given to rectify should be paid, but cannot form part of the amount outstanding on the day the notice was issued. For more information regarding rent payments, please check our information video on rent. Part 4 of the General Tenancy Agreement, or Part 5 of the Rooming Agreement, should set out details for how notices can be issued to either party in the agreement. Please ensure you are delivering the breach notice as per the details provided on the agreement. And finally, check that the dates you are including on the notice are correct and the right timeframes are being provided. As always, the RTA recommends downloading all forms from our website to ensure you are using the most up-to-date version of the form. Should the breach notice be disputed or the matter end up at QCAT, the dates and the information on the form will be checked to ensure correct timeframes have been used, including that delivery timeframes have been taken into account. Now, this slide sets out the steps that can be taken if self-resolution is not possible or not successful. If there is an issue and it's not been resolved after attempting self-resolution, a notice to remedy breach can be issued. Now, please check that the details on the breach notice are clear and the applicable timeframes have been provided. If the breach is remedied, then the tenancy continues. If it's not remedied, then there are options. A notice to end the tenancy can be issued, or a dispute request can be made to the RTA. If the tenant received a notice to leave because of an unremedied breach and they do not leave, the matter can be taken to QCAT to seek a warrant. If a tenant issues a breach and it remains unremedied, then they can issue a notice of intention to leave. Now, the breach in either situation would need to be serious enough to warrant ending the tenancy. So let's have a look at the end-to-end process when issuing a breach notice. The minimum timeframes required to be provided were discussed a couple of slides back, so please ensure you're issuing the notice providing correct timeframes. If the party that received the breach notice rectifies the breach within the required timeframe, the tenancy continues. If a party fails to rectify, then a decision needs to be made. Is the breach serious enough to warrant ending the tenancy, or can the matter be resolved by utilising the RTA's dispute resolution service? If issuing a notice to leave or a notice of intention to leave for an unremedied breach, you will need to check the timeframes that are required to be given, and you must not issue an ending notice before the Form 11 has expired. It's important to note that if a tenant's breach results in the tenancy ending early, they may be responsible to pay compensation in the way of reletting costs. For more information regarding ending a tenancy process, please check our Ending a Tenancy video. As I mentioned on the previous slide, if a party is issued a breach notice and rectifies it, the tenancy continues. But what happens if the party repeatedly breaches the agreement? The Act provides for a repeated breach process. If two breaches have occurred for the same breach and rectified each time, on the third occasion it happens, a property manager or owner can apply to QCAT on the grounds of repeated breaches to end the tenancy, and this is an urgent application. Now, all three breaches must occur within a 12-month period and be for the same reason. Now, this can include a breach of body corporate bylaws. You also need to understand that QCAT will look at the seriousness of the breach, what is the time frame between all the breaches, and look at the evidence provided in relation to the application. If a tenant or resident commits a serious breach, then a different process to issuing a breach notice can be followed. Under the Act, a serious breach is if the tenant or resident or an occupant or a guest of the tenant or resident has either used the property or any property adjoining or adjacent to it for an illegal activity, destroyed or seriously damaged part of the property, endangered another person in the property or nearby, or interfered significantly with the reasonable peace, comfort, or privacy of another tenant or resident. Now, if the tenant is a Department of Housing or Community Housing tenant, they can be issued Form 12 and given 7 days notice to end the tenancy. If the tenant is under a general agreement, the property manager or owner needs to submit a Form 16 and make an application to QCAT to have the tenancy ended due to a serious breach. In a rooming agreement, the resident can be given a notice to leave immediately. Now, we encourage you to check our website for more information if you are considering using these sections of the Act to end a tenancy. Now, in any breach process, the final stage could be QCAT or the Queensland Civil and Administrative Tribunal. Tenancy legislation outlines what is an urgent and a non-urgent application, and there are timeframes that apply for lodging with QCAT. The QCAT website has information regarding the application form and how to lodge, fees payable, and directives on what is required with your application for your matter. The decision is made by the adjudicator on the day and is based on the evidence you provide with your application, and on the day, it is a case-by-case basis for the outcome. Now, please refer to qcat.qld.gov.au for further information about this process. Thank you for listening to our information regarding the breach process. Further information about what I have discussed is available on our website, www.rta.qld.gov.au, or through our other channels, including our YouTube videos and podcasts. Our Friendly Contact Centre can also assist with your tenancy or bond inquiries on 1300 366 311. And to stay in touch and receive regular updates from the RTA, we encourage you to sign up for our monthly email newsletter or follow us on LinkedIn using the details on the screen.